Listen with me for the word of God. The first scripture reading comes from Leviticus chapter 24, verses 19 to 21. Anyone who maims another shall suffer the same injury in return. Fracture for fracture, eye for eye, tooth for tooth. The injury inflicted is the injury to be suffered. One who kills an animal shall make restitution for it, but one who kills a human being shall be put to death. The second reading comes from Matthew chapter 5, verse 38 to 39. You have heard that it was said, an eye for an eye and a tooth for a tooth. But I say to you, do not resist an evildoer, but if anyone strikes you on the right cheek, turn the other also. And if anyone wants to sue you and take your coat, give your cloak as well. And if anyone forces you to go 1 mile, go also the 2nd mile. Give to everyone who begs from you, and do not refuse anyone who wants to borrow from you. These are our scripture readings. Praise be to God.
So the adage of an eye for an eye, or a tooth for a tooth, is of considerable antiquity. It dates back, so far as we can tell, to the time of Hammurabi, who was a famous Babylonian ruler in the time 1792 to 1754 BCE. He was famous because he unified most of what is known as southern Mesopotamia. But he's also famous for his Code of Hammurabi, and in it he included the rule, an eye for an eye. So the principle underlying it is self-evident. It is that a person who has injured another person is to be penalized in a similar degree, and that the person who inflicts the punishment is the injured person. Subsequently, in Hebrew law, and the Hebrew Bible I think was written about 600 BCE, but the Hebrew law put a different nuance on it. It said that the eye for an eye adage was thought not to exact a maximum punishment, but indeed to impose, or I should say not to exact a minimum punishment, but indeed to impose a maximum punishment, a ceiling, so that it should be not more than an eye for an eye. So in the Sermon on the Mount, we heard, Gail reading, Jesus of Nazareth urges his followers, and I'm going to repeat a portion of it. He said, you have heard that it was said, an eye for an eye and a tooth for a tooth. But I say to you, do not resist the one who is evil. If anyone slaps you on the right cheek, turn to him the other also. And the right cheek has some significance, and I'll return to that later. Moving on into the Common Era, many of you will remember the chorus from the Mikado, from Gilbert and Sullivan's The Mikado. It opened in the Savoy in London in March 1885. It was one of the longest running operas there. And the Mikado, you'll remember, it's a story that plays out in Japan, a fictitious story, and it was Japan because it was as far away from Britain as the authors could take it, because it was really a satire. It was a skit on the British institutions of the time. But in the opera, and it's a story about life and death, and love, and flirtation, and cruelty, and capital punishment. But in the chorus of the song of the Mikado, there is the famous line, let the punishment fit the crime, let the punishment fit the crime. Far more recently, in the 1960s, the very famous civil rights leader, Martin Luther King Jr., said that the old law of an eye for an eye leaves everyone blind. And in the interchanges, famous interchanges also between Nelson Mandela and Bill Clinton, and Bill Clinton saw Nelson Mandela as a kind of mentor and came here and spoke with him often. In those exchanges, Bill Clinton reports that Mandela kept reminding him that one's need for vengeance is what captures one. That is what poisons one. Those are the shackles of one's mind. So I want to say something about wrongs in South African civil law in the context of an eye for an eye. So our legal system, as you may know, was brought here by the Dutch in 1652. They brought with them classical Roman law that had then just revived throughout the whole of Europe, including England, but mainly in Holland. And so the system that they brought is classical Roman law and Roman Dutch law. And when the English captured the Cape in 1806, they left in place the Roman Dutch law. But the English educated the judges and the lawyers who practiced the law, and so the English law percolated into our system of the administration of justice. And with it, what percolated into the system of administration of justice was the notion that civil wrongs could be righted by the payment of money. And so in our law today, let me give you 3 typical cases of civil wrongs. The one is defamation. A defamatory wrong is righted not by permitting the injured party publishing whatever he or she wants about the defamer, but by payment of money. The civil wrong of physical injury in a motor vehicle. A person loses his arm in a motor vehicle. Apart from damages for medical expenses and the like, he gets an award of general damages, an amount of money. He doesn't get to chop off the arm of the negligent driver. Unlawful arrest and detention. The policeman who unlawfully arrested and detained you does not himself get detained, but the government pays you an amount as general damages, an amount in money. Now, 2 concluding remarks on the civil system, law system in our country, is first that fixing an amount in damages is obviously a very difficult judicial endeavor. How much money do you put on a lost arm? So you're matching pears and apples, not apples and apples. The other development is in our law of defamation. Take the case of a person defamed by a newspaper who then sues the newspaper and 2 years later finds himself winning in a judgment in a civil court and gets awarded 50,000 rand in damages. Those people who read the newspaper do not know about it, and he's still thought to be a thief as the newspaper published in the first place. And so what courts have begun doing is to direct newspapers to publish in as prominent a place as the first defaming article appeared, an apology. Is this an eye for an eye in a modern form? I don't think so, because still the injured party is not the party who redresses the wrong. But in our criminal law sentencing regime, there is, I suggest, a form of an eye for an eye in a modern cloak. The accepted general principles of sentencing in our law are 5-fold. It's general deterrence, and so the punishment ought to frighten off the community from committing the crime. It's individual deterrence, it ought to frighten off the individual of repeating it. It's prevention, so the individual is removed from society. It's rehabilitation. And finally, it's retribution. So retribution is a valid and accepted means and theory for imposing punishment on criminals. Retribution is vengeance. It's an eye for an eye in a modern form. There's no turning of the other cheek here. And so, in most civilized systems, also in ours, the state takes control of the criminal justice system. It appoints the National Prosecuting Authority, it polices conduct, it appoints courts, it prosecutes people, it punishes them through the courts. So, how does punishment in the courts work? It is primarily the discretion of the trial judge who hears a criminal case as to the punishment that is to be imposed. Again, a money punishment, a fine, that has to fit somehow or another the crime. Let the punishment fit the crime. Eye for an eye. But I have spoken about the 5 principles of criminal sentencing. Judges have developed, since a famous case called State versus Zinn, Z-I-N-N, 3-fold practical means of imposing punishment. I call it the 3 C's: the criminal, the crime, and the community. So the punishment must fit not only the criminal, let the punishment fit the crime and the criminal. So the criminal's personal circumstances are taken into account, and the community's need. And usually the community's need is another way of saying the community's requirement for there to be retribution, for there to be vengeance for what the criminal had done. And as we'll see in a moment, why that is so is, like it or not, unless there is recognition of the community's need for vengeance, the community decides to take back the criminal justice system into its own hands, to bypass the state, and vigilantism rules the day. So it's a fine balance. So, apart from, I have said, the discretion of the trial judge to impose a sentence that fits the crime, community, and criminal, there are what we call the minimum sentencing regimes in our country. When it was first imposed, it met with a lot of judicial resistance. The resistance was that it took away the discretion of the courts, and it was felt that Parliament wanted to, by means of this act, control everything. But in its wisdom, Parliament had considered that particularly 3 crimes, murder, rape, and robbery, were getting out of hand, and that the sentences of the courts were far too lenient properly to address this scourge on our society. And so we obviously don't have capital punishment anymore. I'll speak about capital punishment at the end of this talk. But what we do have is a life sentence. And a life sentence is actually a life sentence. When a court sentences a person to life, that person goes to jail until that person dies. That person can be considered for parole, but as you know, parole is an issue of the Correctional Services Department because it looks at the conduct of the criminal post-sentencing. It looks at the conduct of the criminal in jail. And so that if the criminal's conduct in jail is acceptable and there will have been rehabilitation, then the Department of Justice and a parole board can let a criminal go free on parole. But when you get a life sentence, 2 rules apply. You can't be considered for parole until you have been in jail for 25 years at least. And secondly, you remain on parole until you die. So the sentence is still a real life sentence. There is an exception. Our courts have been called upon in the Act to, in their discretion, lessen the, for instance, life sentences if the court finds that there are, quote, substantial and compelling circumstances. Now, the concept of substantial and compelling circumstances is nowhere defined in the Act, and it was left over to the courts to evolve the concept. The way a court does it is to look at the language, to take out a dictionary, to work out what the language means, and then to say, well, in this case there are or there aren't substantial and compelling circumstances. Once the factual finding is made that there aren't substantial and compelling circumstances, the minimum sentencing regime kicks in, and the case of aggravated rape or rape of a minor, person under 16, you go to jail for life. Now, despite the minimum sentencing regime, and before I give you some examples, let me just remind you what we are talking about today. We're talking about an eye for an eye. And so Parliament reasons that if a minor is raped, and we see it far too often, that person, that minor, is scarred for life. And so it is only appropriate and just and right that the offender should go to jail for life, an eye for an eye, dressed up in modern garb. So just 4 examples of how courts have ameliorated the minimum sentencing effect by applying substantial and compelling circumstances. In a case called State v. Kwaba, 2013, complainant was 14 years old, the appellant was 19 years old. They had known each other well before the incident. He was sentenced to 10 years imprisonment, not life. In Roleli, in 2016, 15 years imprisonment on a 23-year-old accused who raped an 8-year-old boy. In Duplessis, State v. Duplessis, 2016, a 6-year-old girl was raped by her uncle after a braai. 15 years imprisonment, not life. In Duma, 2016 also, 15 years imprisonment imposed on a 60-year-old man who raped an 8-year-old girl. And so these are all examples of cases in which courts have been able to find that there are substantial and compelling circumstances. So when we sit on criminal appeals and we listen to the argument as to whether there are substantial or compelling circumstances, and you confer afterwards, there are, of course, wide-ranging differences of opinion on the same bench as to what are substantial and compelling circumstances. Hopefully it works out for the better, because there is the synergy and the exchange and the enrichment that comes from it. And the upside, of course, is that hopefully some intellectual contribution and morality goes into the process of deciding what is fair and just in the circumstances. Because, as I've said earlier, if the criminal sentencing system is not seen by the community to act in a way that addresses the concerns of the community, take the case of rape, then we see how people get taken out of their homes, how they get stoned, how they get ties around their necks, and the community simply takes back the criminal justice system and takes it away from the state. So the message is, I don't think that we can really escape the substantive message of an eye for an eye. I think underlying it, if properly applied, there is the need for fairness and justice in the measuring out of a sentencing process. Consider, as a last point on criminal justice, the judgment of Judge Moseneke in the Esidimeni arbitration hearings. This is what his order finally read. The Government of the Republic of South Africa, as represented by the National Minister of Health, the Premier of Gauteng, and members of the Executive Government, is ordered to pay an amount of 20,000 rand to each of the claimants listed in A and B in respect of funeral expenses. 2. The government is ordered to pay 180,000 rand to each of the claimants listed in annexures A, B, and C in respect of the shock and psychological trauma. Consider how difficult it was to arrive at that number. How do you measure in rands and cents shock and psychological trauma that those people went through? But thirdly, here comes the interesting and brand new dimension in our country. The government is ordered to pay 1 million rand to each of the claimants listed in Annexure A, B, and C as appropriate relief or compensation for the government's breach of the Constitution. So the new dimension in our land is that the Constitution is, of course, the Vade Mecum, the Bible, if you will, of our morality in this country, of our law. I personally think of the way in which one should conduct one's life as well. And it is one of the ways in which it is protected is to have afforded, and it's in its embryonic stage of development, a claim for monetary compensation to vindicate the Constitution, particularly if government institutions do not vindicate the Constitution. The only way, how else does one bring the government to book if it doesn't honor the Constitution in the way in which it conducts its affairs? And so how else does one do it but by the award of an amount of money? and Justice Moseneke, who's an extremely experienced person in matters commerce, has a good sense of money and money's value, and I am not aware of anyone who thought that R1 million was exorbitant. It's a lot of money, but no one thinks it was exorbitant, having regard to what those people were put through. Again, I ask, an eye for an eye is a just compensation for what had happened? Moving on, our Justice Department has a program called Restorative Justice. Now, restorative justice is an interesting dimension. It is not exactly the question of an eye for an eye, but it does seek to place a different and new dimension on the question of criminal redress for wrongs. It is a program that approaches justice in a way that aims to involve the parties to a dispute and others affected by the harm in collectively identifying the harms, the needs, and the obligations through accepting responsibilities. It sees the crime as an act against the victim, and it shifts the focus to repairing the harm that has been committed against the victim and the community. It believes that the offender also needs assistance, and it seeks to identify what needs to change to prevent future recurrence of the events. I give you one example of this program in action. In the Tembisa Magistrates Court, Simpiwe Hlope was convicted of raping a woman. After a restorative justice facilitator testified in court that the victim's mother had accepted the repeated apologies from Hlope, the magistrate accepted an offer from the offender's family to pay 5,000 rand as, quote, a sign of humanity, in the spirit of a tradition that required that if a person wronged a family, then they were made to pay to that family a fine in cows. So in view of the compensation, the punishment that the magistrate imposed was a 5-year sentence wholly suspended. So I conclude. The criminal justice system is a complex topic in which there are many factors that interplay. Again, from the perspective of the state, it cannot tolerate a situation where its sentencing function is claimed back by society. The reason why it can't allow that to happen in society, to claim back the criminal justice function, is that, surprise, surprise, sometimes the community gets it wrong, and it's the wrong person who gets the tire around the head or the stones on the head. And so society cannot allow vigilantism to reign. State must retain the responsibility and the function for the criminal justice system, but it can only do so if it keeps satisfying the society's legitimate needs, for example, for vengeance. And so, what underpins the notion that one has to turn the other cheek? Can it be that it conveys to the assaulter the message that violence itself serves no purpose? Certainly, that is how many of us, and certainly I, have always understood the Christian message. Violence begets violence. Or is the opposite true, as one theologian suggests? In the time of the Sermon on the Mount, Jerusalem was occupied by the Romans. Roman soldiers walked the streets. They were muscular and arrogant. They looked down on Jews. They looked down on Jews to such an extent that if they were to slap a Jew facing a Jew, and they were mostly right-handed, says this theologian, they would slap them in the face, that is to say, the left cheek of the receiver. That's when they would slap their equal. But when they slapped the Jews, they gave them a backhander, slapping the right cheek. And so this theologian says, look here, what Jesus was saying to his followers on the sermon, in the Sermon on the Mount, was to rise up to the oppression of the Roman soldiers, not to take the degradation that a backslapping implied. Therefore, defiance, not compliance. Therefore, turning the other cheek, not to assist the assaulter, but to challenge the assaulter. It's one dimension, and certainly that's what Leah Watkins, who serves on Citizens for Public Justice, a Canadian NGO, argues. Take the death penalty and its abolition in this country, juxtaposed with its continued frequent practice in America and Saudi Arabia. Most right-thinking lawyers, at least, accept that there is no evidence at all that capital punishment deters murders. After all, if capital punishment did deter murders, there would be no murders in America or Saudi Arabia. In this country, we accepted that the state should not be seen to be matching the violence of the criminal. And so we don't have capital punishment, and we don't have an eye for an eye at the level of murder and at the level of life. We value life greater than we value the vengeance that is measured out by capital punishment. You see on YouTube those pictures, or on popular press photographs, where the families come in America and they sit behind, they sit in pews behind glass, and they observed how the state kills another person. Sometimes the state gets it right. Sometimes they kill the right person, but not always. And so, as a lawyer, I prefer a much simpler explanation for the suggestion that one should turn the other cheek. To me, it means, do not, by the objectionable conduct of others, be drawn down to levels at which you, were it not for the impostor's intervention, would not have been conducting your own life in the first place. Thank you.